Bogle here from Bogle Law. Let's talk about civil domestic violence injunctions. This will be your 2-minute lesson in what are civil domestic violence injunctions. They are a civil proceeding wherein an individual seeks protection from the court against another family member, thus a domestic relationship or situation. And they seek protection because they either are a victim of domestic violence, meaning assault, battery, stalking, or they have a reasonable basis to believe that they soon will be a victim of domestic violence. The way these cases work are that individual will go to the courthouse and fill out a petition for an injunction against domestic violence. A court will look at that petition, read the 4 corners of the document or everything that person wrote, and make an initial determination about whether or not this person is a victim of domestic violence or will likely be a victim of domestic violence. They make that decision ex parte, meaning that the person accused has no opportunity to be involved or to respond. The judge will either issue a temporary injunction against domestic violence and set a hearing approximately 2 weeks later. They can outright deny the petition and not set a hearing, or they can deny the petition and set a hearing about 2 weeks later, allowing the petitioner to come in and present evidence. That hearing is a civil proceeding. The rules of evidence apply. Witnesses are called. Evidence is placed before the court. And after holding a hearing on the petition for domestic violence, the court will either grant a permanent injunction, continue a temporary injunction, or outright deny the injunction. That's your 2-minute lesson on civil domestic violence injunctions. Next time we'll talk about criminal prosecutions in domestic violence.